Good morning, everyone, and welcome to this webinar of Estrada and Aquino Law in cooperation with Rex Bookstore and Raxo City. So this morning, I will share with you very important topics on student discipline, child protection, and of course, teacher protection. Like we always say, learning should not stop even at this time of the pandemic, and this equally applies to us educators and members of the academe as we continue to learn also on the different laws and policies affecting our roles as educators in our respective educational institutions. So I hope you find this useful, especially when you go back after the ECQ and the lockdown is lifted. All right. Now, to start, let's begin with the discussion on the role of the parents in the education of their children. Education is the primary duty of the parents, not of the state. The right and duty to educate, being part and parcel of youth rearing, do not inure to the state at the first instance. Rather, it belongs essentially and naturally to the parents, which right and duty they surrender by delegation to educational institutions. This is the decision of the U.S. Supreme Court in the case of Pierce versus Society of Sisters in 1925. This is a landmark decision on the child rearing rights of the parents insofar as their children is concerned. This is a landmark decision because this is cited by the U.S. Supreme Court and even our own Philippine Supreme Court, even up to this date. In fact, the pronouncement in this case is very important, and that the principle enunciated in this case on the child rearing right of the parents was even reflected in our own constitution. So please check the Article 2, Section 12 of our Constitution. It provides there the primary duty of the parents on the rearing of their children, including education. Also check Article 14, Section 2 of our Constitution. So it's there. This is the source. This case is the source of that principle. All right. So very briefly, this case involves the Education Act passed by the state of Oregon at the time. So in that law on education imposed the requirement on all parents and guardians to send their children and their wards to the public school system if once they reach the school age. So between the age of 6 to 18, the children should be sent to public schools in the state of Oregon, and so this law was challenged by the Society of Sisters. This is a religious organization which operates an orphanage, and the students there were also subject to teachings and provided with education. They opposed the implementation of the Education Act of the state of Oregon because, according to the Society of Sisters, it is the choice of the parents where they want to send their children. So such that the Society of Sisters cannot be compelled to force their students to transfer to the public school system, because the right to raise their children or the child rearing rights pertain to their natural parents at the first instance and not on the state. The duty to educate and to rear their children is merely transferred to educational institutions and by delegation to the state. But at the first instance, the duty to educate students pertain to their natural parents. So that is the decision of the Supreme Court in the case of Pierce versus Society of Sisters. Again, that case is a landmark case. So please take note of that. The child rearing rights of the parents. It is their primary duty to educate their children. Education is not the primary duty of the state or the government, but it is of the parents. So again, please check Article 2, Section 12 of our Constitution, also Article 14, Section 2 of the Constitution. Now, when the parents send their children to school for formal education, their responsibility and authority do not cease, but rather they have, as a matter of law, to cooperate and to coordinate with the school in terms of the implementation of the curricular and co-curricular programs. Again, this duty is a matter of law as provided in the Education Act of 1982 or Batas Pambansa Bilang 232. Our parents have the duty to cooperate and coordinate with the school authorities in the implementation of curricular and co-curricular programs. All right. Now, as parents, they exercise parental authority over their natural children. And parental authority consists of showing love, support, empathy, among others. But most significantly, parental authority includes the duty to educate and discipline the children. Please check our family code of the Philippines. It is enumerated there what consists of parental authority under Article 209 and succeeding articles. And you will find there also the specific duty of the parents to discipline their children under Article 220 of the Family Code. Why is this important? This is important for us to know because while the parents have the primary duty to educate and discipline their children, this parental authority is delegated to the schools and to the teachers once the students are sent for formal education in the educational institutions. And that authority is transferred to the teachers and the school authorities. This is also called the in loco parentis principle. In other words, the teachers and the school administrators stand in the place of their natural parents for as long as the students remain in their custody, instruction, and supervision. Now, this brings us to the next discussion, which is student discipline. Student discipline. All right. So it is now very specific on the discipline of the students or discipline of the child when the child attends school. Now, in an old case decided by the Supreme Court said that the student discipline policies of schools should be coextensive with the school's territorial jurisdiction. In other words, it should only apply within the campus and not outside of the school premises. The Supreme Court said to do that, then the term student discipline would become a misnomer. All right. And that has actually been the mindset of a lot of the students, even up to this very day. And unfortunately, the same sentiment is shared by some educators and teachers. Hindi nga po ba pag merong nag-aaway ng mga estudyante at naghahamunan sila ng away, ano po ang madalas nilang sinasabi? No? Sila ang sasabihin nila ay, doon tayo sa labas, doon tayo magsuntukan. Because their thinking is that they can violate student discipline policies or they can do acts that are otherwise prohibited in campus. Also, they think that if they do it outside they are beyond the reach of the school's authorities. But that is no longer true because of the decision of the Supreme Court in the case of Angeles versus Sison. Please take note of the case Angeles versus Sison. In this case, the Supreme Court said that the the duty of an educational institution is twofold, no? Or the function of educational institutions is twofold. One is to deliver quality and relevant education, and number two, to help shape the character of the students as worthy citizens of the society. And student discipline is the means to perform the second function. In this case, the Supreme Court said that there are instances, therefore, when the student's disciplinary authority applies to students even when they are already outside of the school premises and even beyond school hours. Specifically, these two instances are the following. First, when the conduct of the student is done during a school-sponsored or school-authorized activity off campus. And number two, when the act of the student or the conduct or misconduct of the student affects the good name or reputation of the school. In these two instances, again, the disciplinary authority of the educational institution applies to them even when they are already outside of the school premises. Why? Because of the importance, because of the significance of student discipline in the shaping the character of our students. Because an otherwise implementation of the policy would render the schools powerless in their efforts to shape the values and character of the students. Especially so if the students are free to set aside the school student discipline policies as soon as they have already left the school and are already in their homes. So, in other words, the school policies on discipline follows the student everywhere he goes because it is not for mere convenience of the school or orderliness of the school's premises. Student discipline is for the purpose of shaping the character of the students, again, to be worthy citizens of the society. All right, now I mentioned the two instances where when the school's disciplinary authority applies. No? As we have said, conduct during school-sponsored activity of campus, and when where the conduct affects the good name or reputation of the school. But these instances were further extended by the Supreme Court in the case of Vivares versus St. Teresa's College, where the Supreme Court said that even the conduct or misconduct of students in cyberspace falls within the disciplinary authority of educational institutions. So please take note of that. This is relevant, especially now when our schools will be moving towards flexible learning options, and for some schools it involves online delivery modes of education, and the students will be spending a lot of time in cyberspace and social media. So please take note that the conduct of the students in social media and cyberspace is covered by the disciplinary authority of the school, such that if their conduct affects the good name or reputation of the school can come in and regulate their conduct and even subject them to sanctions. Now, I mentioned the case of Vivares versus St. Teresa's College. Very briefly, this case involves two minor girls who are students of St. Teresa's College of Cebu. And in this case, while the two minor girls, while they were changing in their swimsuits because they were attending a swimsuit party, while they were wearing brasiers and undergarments, they took photos of themselves and posted these photos in their personal Facebook accounts. And this reached the school administration, and the school authorities printed these photos and used them to discipline the two girls, because based on the student handbook of the school, this is a serious misconduct in performing such illicit or immoral acts in taking photos of themselves while only in their undergarments. Because St. Teresa's College of Cebu is a, is a Catholic educational institution, and according to the school, this will be scandalous, and it will damage the reputation of the school as a Catholic educational institution. And so, after due process, the two girls were not allowed to join the graduation march, and as a sanction. And because of this, the parents of the two girls filed a civil case for damages against the school based on the ground of violation of their right to privacy, violation of the right to privacy of the two girls. So bakit naman right to privacy ang violation according to the parents? According to the parents, the school violated the right to informational privacy of the two girls because they had no permission or authority to use the private photos of these two girls posted in their personal Facebook accounts, and that the school had no authority to use these photos to discipline them. And so the case reached the Supreme Court, and the decision of the Supreme Court was in favor of the school. According to the Supreme Court, there was no violation of the right to privacy of the two girls. First, because there is no reasonable expectation of privacy over Facebook posts. According to the Supreme Court, even if the photos are limited to friends' view, the two girls know for a fact that these photos may be viewed by other people who may not be their Facebook friends. And so, therefore, they could not have expected privacy over these photos. And also, Supreme Court said that unless it is shown that the students have that they have employed means to restrict its view to only one person or only to themselves, then they cannot claim privacy over the two photos. But more significantly, in this case, the Supreme Court affirmed the authority of educational institutions over the conduct of the students because of their authority to discipline them. And this extends to the conduct of the students even in cyberspace and social media, particularly Facebook. Now, this case, interestingly, was filed in the Supreme Court while the Data Privacy Act was not yet in its implementation. And it is interesting to find out if a similar case is filed today and would reach our courts, because again, at that time, the Data Privacy Act was not yet in implementation. And now, this is very this has serious considerations now if this happens today, because schools are personal information controllers under the Data Privacy Act, and should secure the privacy of personal information of students. So in this case, hindi natin alam kung meron ng Data Privacy Act noon. Would the Supreme Court have decided the same way? All right. Now, as we have said, but the main takeaway now at this point is that the schools have the authority over the conduct of their students or misconduct of students, even if it is in cyberspace. Now, I would advise the schools that to come up with their social media policy and to make sure that what is prohibited and what is allowed are communicated to the students and to their parents, so that they would know. This is also part of due process, so they would know what is prohibited and what is allowed when they use Facebook and when they interact using the social media platforms. Now, the schools have the authority to promulgate their own rules and regulations to regulate the conduct of their students. And this authority of the schools to have their own policy on discipline is recognized by our Department of Education through the Manual of Regulations for private schools in basic education. And of course, also in higher education. The school's authority to discipline and come up with its own rules of discipline is affirmed by the Manual of Regulations for Private Higher Education Institutions, or CMO number 40, series of 2008. Now, the students have this obligation not only to satisfy or comply with the academic requirements of the school, but equally important is their compliance with the rules and policies on discipline of their schools. It is said that students have their academic freedom, or the academic freedom of students. It consists of the students' right to enroll until graduation, their right to enroll until they have fully completed the course. And they also have the right to be promoted to the next grade level. But this academic freedom of students is not absolute, because it is conditioned on two things: satisfaction of the academic standards or academic requirements of the school, and satisfaction of the standards on discipline or rules and the regulations of the school insofar as discipline is concerned. Because if they seriously violate any school rules and regulations, they automatically forfeit their contractual right to finish the course and to enroll until graduation. Please take note of that, because that is very important. Pag may nagreklamo sa inyo na estudyante or na parent kung bakit bakit binagsak ng teacher. No, for example, bumagsak sa kanyang subject. Bakit bumagsak? Bakit hindi ninyo pinapayagan na ma-promote sa next grade level, or bakit hindi pinapayagan na graduate? This is the answer. The obligation of the school to educate a student would imply a corresponding obligation on the part of the student to study well. And so there is that duty to study well. Kung meron namang hindi na pag-graduate because of serious violation of the school rules and policies on discipline, pagka kinwestiyon yung decision ng school, bakit hindi pinag-graduate? Bakit in-exclude? Bakit hindi na pinayagang makapag-enroll? Because of the seriousness of the offense. Ang sagot po dyan, again, the obligation of the school to educate the student would imply a corresponding obligation on the part of the student to obey the school rules and regulations. Otherwise, as I've said earlier, the student who fails to meet the academic standards of the school and fails to follow its reasonable school rules and regulations, the student automatically forfeits his contractual right to finish the course. All right. Now, on student discipline, student discipline, the issue on student discipline is where do we draw the line between the authority of the parents to discipline their child or their children and the school's authority to impose an exact discipline on their students. So madalas nag-overlap yan. And this is the oftentimes the source of misunderstanding between the parents and the teachers and the school authorities. Hanggang saan po ba yung hangganan ng authority ng paaralan para disiplinahin ang mga estudyante? At hanggang saan din pwedeng makarating ang karapatan ng magulang para disiplinahin ang kanilang mga anak. So oftentimes these two principles clash. All right. Now, in explaining this, I usually show this comic strip. This comic strip where a teacher calls to the school a parent, in this case a mother. So sabi nung teacher dun sa magulang na pinatawag niya papunta sa school, sabi niya, I called you because your son is misbehaving in class. Ang sagot sa kanya ng magulang, he is also misbehaving at home. Pinatawag ba kita? So, you see there's a conflict. This shows generally the boundaries. When the students are in school, their discipline and education are entrusted to the teachers and the school authorities. But when they leave the school premises and then they go home, then the parents are in charge of their discipline. But again, as discussed earlier, nag-overlap yon because again, as decided by the Supreme Court in Angeles versus Sison, the disciplinary authority of the school transcends or goes beyond the territorial jurisdiction of the school because the purpose is to shape the character of the students. So, paano yan? Paano natin i-reconcile yan? No? And to reconcile this, it is important to understand the principle of in loco parentis. All right. Now, in loco parentis principle, literally, it means in the place of the parents. Teachers and school authorities are said to be in loco parentis insofar as their students are concerned, while the students are under their supervision, custody, and instruction. Okay, sinasabi natin kanina, yung authority of the parents over their children to educate them and discipline them, this authority is transferred to the teachers and the school authorities when the students are in school. All right. Now, when the students are in school, the teachers are in loco parentis over them, over the students, and they exercise special parental authority according to the Civil Code of the Philippines. They exercise special parental authority. Ano pong ibig sabihin ng special parental authority? It simply means that the whatever is included in the term parental authority as exercised by the natural parents over their children, this is now exercised also by the teachers and the school authorities. So, ibig sabihin, yung duty to discipline the students is now also the duty of the teachers over their students. And that duty to discipline the students while the students are in school, that is exclusive to the educational institution. When I say exclusive, not even the parents can can intervene and interfere with that authority, as long as, of course, such disciplinary authority is not abusive or does not amount to a crime. Okay, again, it is exclusive to the school. Why? Why is that? Why is that so? Well, because the law is fair. The law is just being fair because when there is failure to discipline a student or failure to discipline a child in school, and that child injures or damages another, say for example a classmate in the school, the liability of the teacher who is found negligent, the liability is joint and solidary. Ibig sabihin, no, in layman's terms, as if siya na yung naka-injure or damage doon sa nasaktan ng bata. His liability, the liability of the teacher is joint and solidary. What about the parents who are at home or elsewhere? Meron ba silang liability? Yes, meron din silang liability, but their liability is lesser than the liability of the negligent teacher. The liability of the natural parents is said to be subsidiary only under the law. Ibig sabihin ng subsidiary only when the injured party could not claim in full from the school and the negligent teacher. That's the only time that it can claim against the parent of the minor, and only to the extent that it's not satisfied by the teacher and the school. So fair yung batas, no? Since the teachers and the school authorities are exposed to greater liabilities in case of their failure to discipline a child or a student, and that student injures or damages another person, it gives them flexibility and more a wider latitude in imposing student discipline over the students. Kasi nga, pag may nangyari, pag nakasakit yung bata na yan ng ibang bata sa eskwelahan, the liability is greater. All right, so you see, the clash between the authority of the parents and the school insofar as discipline of the child is clarified by this principle of in loco parentis and special parental authority. So, maliwanag po. No? And again, you should always remember that, again, as I've mentioned earlier, the duty of the parents includes to coordinate and cooperate with the school authorities insofar as the implementation of school policies. So, hindi po pwede na i-violate din ng parents yung policy on student discipline of the students, no? Lalo na ngayon, no? Because of flexible learning options that will be implemented by the schools, this will require more participation of the parents because the students will be spending more time at home with them. And there will be lesser intervention of school authorities and the teachers. The teachers will provide the learning kits, learning materials, and instructions, but it will be the parents who will be facilitating the learning at home. And so, it is important for the parents to understand their role, which is to cooperate and to coordinate in the implementation of school policies, including the policies on discipline. Alam po ninyo, madalas may mga naririnig ako na when students are being subject to disciplinary rules of the school, of course, naturally, their parents would come to their rescue or defense. No? Without understanding the importance of the values being inculcated by the school to the student by enforcing the school policy on discipline. Merong isang example, no? In one school, the school of course, prohibits smoking of minors. And one time, one of the students was caught by the teacher outside of the school premises smoking. And when the attention of the student was called and when the parents were informed, ang sagot po ng parents ay pinapayagan naman namin ang aming anak na mag-smoke as long as he is under our care. No? Pinapayagan namin sila. So, that is not an excuse because remember, the duty of the parents include their duty to coordinate and cooperate with the school authorities in the implementation of school policies. Section 14 of BP 232. Please take note of that. So, anong gagawin natin? In that case, na nag-smoke, sabihin ng school, ang sanction po dyan sa smoking is suspension. Sabihin ng tatay, pinapayagan ko siyang mag-smoke basta nalalaman ko at nakikita ko basta kasabay ko. What do you do? Di suspend na rin natin yung father. Dalawa silang masuspend. Okay. Now, as I mentioned earlier, there is joint and solidary liability of teachers and school administrators when they are exercising special parental authority over their students. And the defense on liability claims against the school is the exercise of due diligence of a good father of a family. Reasonable diligence lang is required. The school is not expected to be an insurer of all risks, but it is expected and it is required by law to exercise due diligence in making sure that the students are safe and secure. All right. So, yung in loco parentis principle is a liability principle, but it is also a source of a right of the teachers and the school authorities. Bakit siya source of a right? Because this is also the reason why the teachers may exercise parental authority over their students because they stand in loco parentis insofar as the students are concerned. It is also a source of liability because they are in charge of the safety and security of these minors, and these students should not or should be disciplined in order not to damage or injure other persons in the academy or in the school. But it only applies in student discipline cases. No? Yung in loco parentis applies only in student discipline cases. Tulad ng example ko na yung isang bata, tinusok niya ng lapis yung kaklase niya while in class. The liability of the teacher in failing to discipline the child is based on the in loco parentis principle. Because there is failure to discipline the student and the student consequently damaged or injured another student in the school. Okay. I'll tell you about an actual case. All right, and this is related to the liability of school in loco parentis. All right, the in one of the case on student discipline, one of the cases on student discipline, the student on his way to the school had a fight, had this altercation and argument with a bystander who is not a student in the same school where the student goes. So on his way, he had this altercation with the tambay, with the bystander, and he was able to enter the school premises, thinking that he's already safe there. So the student went inside the school, and the bystander was not allowed to go inside the school premises. But this bystander was able to find his way to enter the school premises using the back gate. And once already inside the school premises, he was able to assault and inflict harm, physical and bodily harm, on the student, and the student suffered injuries and damages. Now, question: is the school liable in loco parentis for the damages incurred by the student by reason of the assault of the outsider? If your answer is yes, you press a thumbs up sign. If your answer is no, the school is not liable, you click the heart sign. No? So ano pong sagot doon? No? The answer is no. The school is not liable in loco parentis. Why? Because the case does not involve failure of discipline. Because the school is not in charge of the discipline of the outsider. So it is not liable in loco parentis. But is the school liable anyway for the damages or injuries incurred or suffered by the student? And the answer is yes. What is the basis for the liability of the school in this case? The basis is breach of contract, or the breach of the contractual obligation of the school to maintain a safe and secure learning environment for the students. So the liability is breach of contract. Okay, students have the right to safe and secure learning environment while they are under supervision, custody, and instruction of the school. Now, here are some of the laws and regulations which deal with child protection. Okay, so it is required that schools comply with all of these laws that I will enumerate, because failure to comply with specific requirements on these laws would mean negligence on the part of the school, on the part of its teachers, and it opens the school and the teachers to liabilities, including criminal liabilities. So here are some of these laws. Now, of course, on top of the list is the Republic Act 7610, or the Anti-Child Abuse Law. All right, if the school fails to satisfy or comply with the requirements of the Anti-Child Abuse Law in the school, then it cannot claim that it has exercised due diligence. All right, now the Anti-Child Abuse Law is implemented in the basic education through DepEd Order Number 40, Series of 2012, also known as the Child Protection Policy. You also have the Anti-Bullying Act. This is the law which requires all basic education institutions to have its own anti-bullying policy. So if a student is bullied in school and the school says we are not liable because we have exercised due diligence, due diligence would mean that the school has in place an anti-bullying policy. Because without the anti-bullying policy, the school cannot claim that it has exercised due diligence, because it is a requirement of the law. It is the minimum requirement of the law. Then you also have the Safe Spaces Act, or Bawal ang Bastos Law. This was signed into law last year. Bawal ang Bastos Law prohibits wolf whistling, cat calling, persistent green jokes. O bawal na po yan, no? Bawal ang Bastos Law. So you might also want to ask, what is the difference between the Anti-Sexual Harassment Act and the Bawal ang Bastos Law? No? Parang pareho lang yan, kasi yung sexual harassment in the education setting also prohibits the same acts. Ang pinagkaiba po nila, ang main difference is that in the Anti-Sexual Harassment Law, in order to qualify as sexual harassment, there should be moral ascendancy over the victim. There should be moral ascendancy, influence, or superiority over the victim. Without that superiority moral ascendancy, there can be no crime of sexual harassment. But in the Safe Spaces Act, there is no such requirement. So the victim may even be the superior of the harasser. Uh, So this is implemented in the school. No? This is implemented in the school. In fact, if you read this Safe Spaces Act, it requires the schools to resolve complaints, even anonymous complaints. Yung mga complaints ng pambabastos, it should be resolved within 10 days. Otherwise, the school head will be made liable. O ganun po ka, stricto yung batas. But the bawal ang bastos law, I think the implementing rules and regulations is being finalized because of this, because of some difficulties, no, in satisfying the provisions of the law. Then of course you also have the Mental Health Act. Bakit po siya relevant sa child protection and student protection? Because here there are express provisions of the law in making sure that our educational institutions have sufficient number of mental health professionals to help students who may be at risk, who are considered at risk of because of depression, even addiction, and other mental health issues. Prior to the Mental Health Act, under the Guidance and Counseling Act, di ba, ang required ratio in the schools for guidance counselors, the student and guidance counselor ratio is 1 is to 1,000. But now, there is this Mental Health Act which requires sufficiency in the number of mental health professionals. And mental health professionals in the school refer to our guidance and counselors. There should be enough guidance counselors in the schools. Otherwise, the school may be held liable if some students who are considered as at risk suffers damages, and some even succumb to suicide, depression. So the school may be held liable if it is shown that the school has not complied with the requirements of the mental health law. Then, of course, you have the Data Privacy Act of 2012, which protects the privacy of personal information of students, so that their personal information shared to the school may not be shared to third parties without permission from the parents or the students themselves, or that this information may not be processed without their consent and knowledge. So please take note of these laws, because compliance with all of these laws mean exercise of due diligence. And conversely, if you do not follow or you don't satisfy the requirements of this law, then you are rendered negligent and you may be liable for damages. All right. Now, child abuse. This discussion on this law is very important because it involves a child. And in our schools, we have minors, and they are vulnerable, and they are, of course, subject to the application of the Child Protection Act, Child Protection Policy of the Department of Education, and the Anti-Child Abuse Law, or RA 7610. So what is child abuse? Child abuse is any maltreatment of a child, whether habitual or not. And please take note, it is committed over a child, meaning a minor, or a person who is deemed a child as defined in RA 7610. So if the prohibited acts under the law, under this law, is committed over a person who is already of majority age, then there can be no violation, or there can be no crime of child abuse. Child abuse includes the following acts, no? Or the following abuses: psychological, physical, even sexual abuse, or acts or misdeeds which are debasing, degrading on the child, or failure to extend the assistance to students who are in emergency situations, and also failure to provide the basic needs of the minor. So neglect is also a form of child abuse. So again, all of these acts, if committed over a minor person or over a child, is child abuse. Now, it is critical for the implementation of the law in looking at the definition of a child. No? Because if the person is not considered a child under the law, then there can be no child abuse. Probably there is some other crime, but not child abuse. All right. Under RA 7610, a child is defined as a person who is below 18 years of age, of course. But the term child also includes a person who may be 18 years of age or over, but is incapable of protecting himself or herself from abuses due to some disability or mental health condition. So that person is also considered a child under the law. And the commission of the prohibited acts against this person is considered child abuse. Interestingly, the Department Order number 40 of the DepEd, DO 40 series of 2012, has a different definition of a child. Under DO 40, a child is any person below 18 years of age or 18 years of age or over, as long as that person is still in school. So, of course, there's a very big difference from the two definitions. And the Department Order number 40, being an administrative issuance, cannot expand the definition of the law on a child, the definition of a child under the law, because as administrative issuance, it should only be germane and should be limited by the express provisions of the law that it is implementing. So I hope this oversight, I hope this will be corrected by our Department of Education. With all due respect, if we have some officials from the Department of Education attending this webinar, sana po iyan ay makorek. Lalong-lalo na ngayon dahil because of the implementation of the K-12 law on the senior high school program, our students have become older, and our teachers are getting younger. No? Our teachers now are as young as 21, 22 years old, and our high school students are already of majority age. No? Some of them in senior high school, in grades 11 and 12, yung iba dyan 18 na, turning 19, and some are even older. That's why the definition is very important. You can imagine a senior high school student already of majority age may complain of child abuse against his or her teacher, and the teacher is about the same age as the student. No? The student may complain of psychological abuse when shouted upon or feels slighted. It's possible it will create an absurd situation where a student who is already of majority age complains of child abuse. And I'll exaggerate siguro a little. What if the senior high school student is already a senior citizen? No? Pwede rin ba siyang mag-complain ng child abuse against the teacher? Siguro hindi naman, ano? It creates an absurd situation. So again, I hope that aspect, that part of DO 40 be corrected by our DepEd officials. But other than that, honestly, DepEd Order Number 40, Series of 2012, is one of the landmark issuances of the Department of Education because it provides policies on anti-bullying, anti-corporal punishment. In fact, the anti-bullying policy in DepEd Order Number 40 was put in place even before the enactment of the anti-bullying law. Bago pa nagkaroon ng anti-bullying law, meron ng anti-bullying policy ang Department of Education. And also the anti-corporal punishment policy of the Department of Education under the same Department Order Number 40. Wala po tayong batas prohibiting corporal punishment except that provision in our civil code which says that those who are exercising parental authority shall not subject the minor to any form of corporal punishment. Yun lang po, no? Pero wala pong isang buong batas which defines what is corporal punishment and provides what are the forms of corporal punishment. Wala pong batas. Pero meron po tayong DepEd Order Number 40, Series of 2012. And it is listed there, the forms of corporal punishment that is not allowed in the schools. Nagkaroon na po ng mga proposals in Congress. In fact, I think for several times, the Congress has approved a bill on anti-corporal punishment, but it was not signed into law by the President or by the executive. Okay, now, the anti-corporal punishment involves punishment which may be in excess of what is reasonable and what is commensurate to the infraction of the student. This may involve physical labor or punishments that are degrading or embarrassing. This is no longer acceptable, no, in our society. So, bawal na yung nagpapaluhod sa munggo kapag Biyernes. Bawal na yung naglalagay ng libro sa kamay habang nakaluhod. So, hindi na po pwede yan. Bawal na yung mga physical punishment. Bawal na yung binabatukan, pinipingot, ginugupitan ng buhok. So, hindi na po yan allowed, no? Because it falls under the prohibited corporal punishment. And student discipline has evolved now, no? And it is now following the principles of restorative justice in student discipline. So it follows that reformative or rehabilitative aspect of student discipline, which focuses on the reformation of the student and not on the gravity of the offense, and certainly not on the punishment over the student. So hindi na po yan ginagawa, no? Bawal na ang corporal punishment. So ano po yung mga allowed na punishment sa yung community service madalas na itatanong, pwede ba nating i-subject sa community service ang mga bata without violating this anti-corporal punishment policy? The answer is yes, no? As long as the community service is not hard labor, it is not embarrassing, pwede pa rin naman, no? Ano ba yung mga community service usually na allowed sa schools? If the students will be asked to write an article in the school paper, if the student will be asked to assist certain offices in the school, like the guidance office, also the student discipline office, as long as, again, the work being asked for the student to perform is does not consist of hard labor or physical work, and those that are not embarrassing, yung pinaglilinis ng CR, no? Unless na lang siguro tanggalin yung vandalism that the student himself created, no? So pwede po 'yan. Pero bawal na yung ayun, naglilinis ng CR, no, toilet bowl, or naghuhukay ng swimming pool yung sa backyard ng school. Bawal na po 'yan, no? Because it violates the anti-corporal punishment of the school, and it may even consist of child abuse as a crime. So please take note of that. Okay. Now, as mentioned earlier, part of child abuse is sexual abuse. And as part of the duty of the school to maintain a safe and secure learning environment, it should also secure the student from any form of sexual abuse or abuses from the school personnel themselves. No? So, kasama po yan sa responsibility ng school. Now, in relation to this, I'd like to discuss with you a case involving a faculty and a minor student. No? This involves a faculty, a male faculty who is already of legal age, around 25 years old at that time, and the student who is a minor, 17 years old at the time, a minor student, a female student, who was in her freshman year when she was courted by this professor. When she was courted by her professor, who is also single, but is already of legal age. But at the time the professor was courting her, the professor was trying to get her to a hotel room and watch Kama Sutra and to teach her sex education. But the student would not fall, no, for his advances. But because of his persistency in courting her, after some time, the student gave in, no, and said yes to the professor, and so they had this romantic relationship. So they became girlfriend and boyfriend. And being in a romantic relationship, they entered into sexual relationship. No? But after some time, the student discovered that this professor boyfriend also had other girlfriends in other schools where he taught, and so they broke up, or kahiwalay sila, and heartbroken yung student, and she confided with her parents, and she was in the process, she was forced to admit to her parents that she had sexual intercourse with her boyfriend, who happens to be her professor. Upon learning this, the parents said they will file a criminal case for child abuse against the professor. But the student said, we will be embarrassed because I gave my consent to him because we were in a relationship. But the parents said we already consulted a lawyer and that we will file a case against this professor for sexual abuse under RA 7610, or the anti-child abuse law. And so they filed the case. And the professor, as a matter of defense, said that since they were in a romantic relationship, that sexual intercourse is presumed to be consensual. This, in legal parlance, no, on legal terms, this is referred to as sweetheart theory principle. Now, this is normally used in the rape and acts of lasciviousness cases, where the accused, as a matter of defense, cites the romantic relationship with the woman, and that since there is consent, or the consent is presumed, a complaint for rape or acts of lasciviousness will not hold water. So it was the same defense that this professor used in this child abuse case filed by the minor student after a consensual sexual intercourse. And the Supreme Court decided in favor of the student or the minor and convicted the professor of child abuse through sexual abuse. And the Supreme Court set aside the defense of consent. The Supreme Court said, regardless whether there is consent or not, because as a minor, the student was incapable of giving her rational consent to any sexual intercourse or any acts of lasciviousness. So please take note of that. No? The case is Malto versus People of the Philippines. This case was decided in 2007, and this is the prevailing jurisprudence on this matter, insofar as sexual abuse of faculty over a student. So regardless whether there is consent or not, even if there is consent, it is still child abuse. Because according to the Supreme Court, a child is incapable of giving rational consent to any form of sexual intercourse or acts of lasciviousness. So medyo ano lang yun, ano, in reality, medyo hindi na ganon ka-accurate yon, no? Imagine a 17-year-old, no? Baka sa panahon ngayon, yung 17-year-old, iba na pag-iisip, no? Maaring hindi na ganun ka-accurate yung pronouncement na a minor, a 17-year-old, is incapable of giving rational consent to any sexual intercourse. But nevertheless, this is the standing jurisprudence, no? So it reminds us, those in the academy especially, that they cannot have a romantic relationship, they cannot engage in sexual relationship with their students. And if they are minors, there is still, it amounts to a crime even when there is consent. Okay, Malto versus People of the Philippines. Now I'd like to discuss with you another case which involves the same issue on a relationship between the teacher and the student. But this case was decided much earlier, around 1990. It's very interesting. But this case is still applicable up until today, insofar as the totality of circumstances principle introduced by the Supreme Court through this case. That in any case where what is in issue is the morality of the person, the Supreme Court said the totality of circumstances principle should be applied, and that the focus should not be on the act subject of the complaint, but there should be focus or consideration on the totality of circumstances. So yan po ang takeaway dito. Inuna ko na yung takeaway. No? This is the takeaway in this case. But it involves a similar issue on the case of Malto versus People of the Philippines. But only this time, the teacher involved is a female teacher, 31 years old, single, who had a relationship with her minor student, also minor, a boy, 15 years old at the time. All right. So because of this romantic relationship, the teacher was dismissed from her employment because of disgraceful and immoral conduct under the school policies and under the manual of regulations. As a matter of defense, the teacher said that she and the boy did not commit any immoral act inside the school premises, and there was no proof that they engaged in illicit or immoral activities. But she admitted that they are into a romantic relationship, that she indeed is the girlfriend of her student, who is a minor. And the school said this is scandalous. Goes against the function of the educational institution. It does not subscribe to our values, and so therefore we are dismissing the teacher on the ground of disgraceful and immoral conduct. Now, the teacher said, as a matter of defense, again, that there was no immoral act. But the school insisted that since they are in a romantic relationship, which they admitted, it is safe to presume that they are engaged in sexual activities which are immoral. Sabi naman ng court, well, that is something that's left to the imagination, but unless there is proof, it cannot be conclusive. So without that, we cannot assume without evidence. The only evidence the only fact that was established is that indeed there was a relationship between the teacher and the boy. In fact, when the boy reached legal age or majority age, they got married. The teacher and the student got married. And the Supreme Court eventually decided in favor of the teacher. So the Supreme Court said that there was no basis for her dismissal on account of disgraceful and immoral conduct. And the decision of the Supreme Court is very interesting in this case. The Supreme Court said in its decision, explained its decision in favor of the teacher in saying, if the two eventually fell in love, despite the disparity in their ages and academic levels, this only lends substance to the truism that the heart has reasons of its own, which reason does not know. And the universal feeling of love cannot be equated with immorality. So yan ang decision ng Supreme Court. But the takeaway in this case is the totality of circumstances. So in this case, the Supreme Court said that there was no abuse. There was no abuse. There was no immorality here, in consideration of the totality of circumstances. So you just compare this with the case of Malta versus people of the Philippines, diba? I don't think that the accused in Malta versus people of the Philippines would avail of the same excuse or reason as cited by the Supreme Court in this case. Hindi naman pwede sabihin if the two fell in love this party, because there was the impurity of intention was already manifest at the outset in the earlier case that I've cited. So anyway, of course, if there is a specific provision in the school's faculty manual or teacher's manual that prohibits relationship with the students, of course, this will also prevail and may be the basis for termination of employment of the teacher. So, the case that I just discussed is the case of Evelyn Chuakwa versus Clave. This was decided by the Supreme Court in 1990. So, yung mga teachers natin, do not get into a relationship with your students while they are still your students. Hintayin na lang ninyo makagraduate. Alagaan nyo na lang muna. Kinder pa lang, bantayan nyo na. Hintayin nyo gumraduate ng senior high or ng college. Yeah, just kidding. Okay. This is very relevant. I also mentioned this case because this finds relevance, especially nowadays when the student and the teachers interact in cyberspace, in social media, and when they do interact, they interact like normal individuals, not as teacher and students. So it's possible that they develop into some affection or liking or even an attraction or a relationship between them or among themselves. So it is dangerous now. It's very dangerous now. So it helps a lot now in reminding us of our professionalism and our duty as teachers and members of the academy. All right. Now, let's discuss the liabilities of the school. We already covered that. There's a case uh, on the liability of the school to maintain a safe and secure learning environment. The case of St. Luke's College of Medicine versus Quasha Medical Foundation versus Spouses Perez. This was decided by the Supreme Court in 2016. And here the issue is whether the school has exercised due diligence, no, um, in in uh, in uh, in maintaining a safe and secure learning environment for its students. All right, in this case, it involves students who are under clerkship, and the school entered into an agreement with the municipal clinic for the students to report there and do their rotation, their duties. One day, the students who were reporting in the municipal clinic died because a fire broke out in the municipal building. And so the parents of the students sued the school for damages for breach of contract in failing to providing a safe and secure learning environment. But the school said that the fire was in the municipal building maintained by the municipality of Cabiao, Nueva Ecija, and that the responsibility to maintain the security of the premises is with the municipality, not with the school. And according to the school, it has exercised due diligence and it should not be made liable for the death of the students. It was later on found that the cause of the fire is and the death of the students and other persons is on the failure to follow the fire and building code of the Philippines. And again, according to the school, that is not the responsibility. That is not their responsibility because the municipal clinic building is maintained and owned by the municipality. But the Supreme Court said no, the school is liable because it has failed to show that it has exercised due diligence. And that responsibility extends to the municipal building because they sent their students there for rotation. And according to the Supreme Court, there was not enough, there was no sufficient proof that would show that the school has exercised due diligence. And in fact, according to the Supreme Court, there was the school did not even send its student affairs, the dean of its student affairs, to monitor and check to conduct a site monitoring of the municipal clinic if because anyone could readily see that the structural defects of the municipal building, walang enough fire exits. But the school was remiss on this duty. It did not even conduct a site inspection before sending out the students. So on this score, the Supreme Court said that the school is liable for the death of the students because of its failure to maintain a safe and secure environment for them when they were sent out to the municipal building to do their rotation. All right. Now, another issue related to the the obligation of the school to maintain a safe and secure learning environment for the students is the issue on waivers. All right. So this is often asked, no, is a waiver valid? No, is it against the law to require the students and the parents to sign a waiver before they participate in an activity off campus? Is that illegal? No, that's the question. Well, the answer is no. It is not illegal. Waivers are valid. In fact, under Article 6 of the Civil Code of the Philippines provide provides that waivers are valid for as long as this is not against good customs, public policy, and the law. So waivers are valid. No? What is the difference between a waiver and a consent form being required by the schools to for the parents and the students to sign? Ang pinakaiba po niyan, ganito, yung consent form merely informs the student and the parents of the activity, and they sign their express their conformity, or they express that they have read the information by signing on the consent form. A waiver, on the other hand, is different because a waiver is in the nature of a contract. Yun ang main difference sila. Ang waiver is a contract by itself. So when the waiver complies with the requisites of a valid contract, it has the same force and effect of a contract, and it is said to be the law between the parties. Is it illegal? Is it invalid? Is it unenforceable? No. Only the courts can declare contracts as invalid and or unenforceable. No other agency can declare a contract as invalid or unenforceable. The waiver is founded on this Latin maxim, volenti non fit injuria or injuria, which means that to the willing there is no injury. So please remember that, no, that legal maxim as the basis or a foundation of the validity of waivers as a contract or agreement. As I've said, it is the law between the parties. However, while it may be valid, it is not always enforceable against the students and their parents in a case for damages based on negligence. So hindi porket valid yan it is always enforceable. Ano ibig sabihin ng enforceable? No? When something happens, when a student dies or is injured after attending a school activity and claims damages from the school, and here the school shows the waiver signed by the parents, can it really be enforced? In other words, can the school avoid liability by showing the waiver? Well, that is not always the case, because while a waiver may be valid because it has complied with the requisites of a valid contract, it doesn't follow that the contents are enforceable. Once the waiver is signed by the parent on behalf of the minor student, and the waiver is also signed by the school authorities, then there already is a valid waiver. Valid na yon. But the content may not necessarily be enforceable. To be enforceable, the content of the waiver should comply with the following. No? The waiver should be worded to clearly release the school from any liability on certain damages, and that the parents clearly agree. Because the parents could not have agreed to a vague waiver. So dapat specific ano yung damages that the school declares that it is not liable, and what are the circumstances under which the school will not be liable. And there should be no coercion or pressure for the parents to sign, and that the student and parents should know all the inherent risks involved before they sign the waiver. So a general waiver which says the school shall not be liable for any death or injury occasioned in the field trip or school activity, that is not a valid waiver. The waiver should provide the specific liabilities that the school declares that it is not liable. Ano po ang example niyan? Well, for example, the school states in a waiver that it is not liable for injury or death on account of unroadworthiness of the bus, for example, or driver error, especially when the when the transportation is outsourced to a company, to a provider, and not provided by the school. So in these instances, the school is within reason to transfer the liability to the transportation company, and that once the students and the parents agree, then the waiver is enforceable as between them. But of course, the parents are free not to send their children, and there should be an alternative activity by the school so that the students are not coerced to go to the field trip or the off-campus activity. All right. Our next discussion is on cyberspace and the internet. And this is very relevant nowadays. Ayoko na sanang i-discuss, ang haba na. Pero I hope you still have the energy to listen to this discussion. Wala pa nga tayo sa teacher protection. No? Now let's go to the discussion on freedom of speech and expression and the right to privacy in cyberspace versus academic freedom and the right of the school to discipline. Now, this is very relevant nowadays, yung freedom of speech and expression. Just last Tuesday, it was in the news. A teacher was arrested because he posted that he will give 50 million pesos to any person who would kill the president. So, we have so many cases like this where a lot of people express or made their expressions on cyberspace and social media, but without restraint, without self-restraint, and without due regard to the rights of others. So we should be careful, especially being members of the academe, being an educator. We should be cautious with our conduct. We should subscribe, no? As teachers, we should subscribe to a certain norm of conduct for teachers. All right, freedom of speech and expression. Okay. I'll start this discussion on this topic with a discussion on a case, again, a landmark case, the case of Tinker versus Des Moines. All right, Tinker versus Des Moines. This is a case decided in the U.S. Supreme Court in 1969. Now, this is the landmark case involving freedom of speech and expression of students and teachers in the school. All right. Now, so in this case, very briefly, the facts are as follows. In 1968, there were 4 students in the district community school who tried to enter the school premises wearing black armbands as a sign of protest against the U.S. hostilities in Vietnam at the time. They were not allowed entry in the school premises, but they said that we are merely expressing our opinion, and this is a silent protest. We are not disrupting the school activities or the classes. But they were barred from entering the school premises, and so they filed an injunction case and claimed for damages against the school. And the Supreme Court decided in favor of the students. And this case of Tinker is well known for the opinion of the court delivered by Justice Fortas in saying that it can hardly be argued that teachers and students shed their constitutional rights at the schoolhouse gates. So, ibig sabihin, the students continue to enjoy their freedom of speech and expression even when they are in the school premises. But the Supreme Court also provided certain exceptions. that the teacher and the student cannot um, use the constitutional immunity from liability if the expression substantially disrupts a school activity or that there is material interference with the school policy. On those two instances, again, the expression of the teacher and the student cannot be subject to the constitutional immunity of freedom of speech and expression. So, in other words, if your expression disrupts a school activity or materially interferes with the rights of the others or interferes with the school's policy, then you cannot claim freedom of speech and expression. So 1969 yan, wala pa namang Facebook noon, wala pang social media. But the same principle is being followed until this very day. In fact, yung kaso na yan is cited by our own Supreme Court in a long line of cases. Non versus Daines, Malabanan versus Ramento. No? Marami na po tayong mga kaso na sinasite yan. So please take note of that. No? While the general rule is that the teachers and students do not shed their constitutional rights to freedom of speech and expression at the schoolhouse gates, they cannot claim such constitutional immunity if their expression substantially disrupts the school activity or materially interferes with the school policy. Now, the same principle applies even when the expression is on social media and cyberspace. So please take note of that. So now, it is also relevant when it comes to freedom of speech and expression and cyberspace, the duty of the school to maintain a safe and secure environment for students when they are using digital platforms. In other words, the duty to provide a safe and secure learning environment extends to cyber security. So how can we protect our school and our students from cyber abuses, harassment, and dangers? We should be able to monitor their activities on Facebook and social media. So again, I'd like to reiterate the need to have our social media policy in our schools. And we should also be mindful about the risky behaviors that are usually developed by persons who are always online, and especially for students. And I refer to three, very important for us to know: risky behaviors of students who are always online. These are cyberbullying, cyber harassment, and sexting. Students who are always online are prone to develop these risky behaviors of cyberbullying, cyber harassment, and sexting. Cyberbullying is the same bullying that is done in person, except that it is done in cyberspace. Harassment or cyber harassment is the same as bullying, except that it is participated by an adult in cyberspace. And sexting is a combination of two words, sex and texting. A lot of students are victims of this, have developed this risky behavior, and it's too late when they discover that they should not have allowed themselves to develop this risky behavior. Yung sexting po, it starts with an innocent text, probably mga green jokes, and because everybody's doing it, you feel that this is okay, then probably you'll be sending nude photos, and worse, sending nude photos of yourself. No, that is sexting, and that should be prohibited in all educational institutions. And for me, that should be part of every student handbook in every school. Marami po tayong nabalita na ganyan, di ba? Last year or 2018, I think, there's this case in one of the schools where students, the male students, shared the photos of their ex-girlfriends, no, and they were all graduating students, diba? So um, it is too late for even for the girls to realize that they should not have engaged in this practice of sharing photos of themselves while in the nude. All right, so they should be addressed in the schools. No? So cyberbullying, cyber harassment, and even sexting. All right, now let's as the last topic for us in this webinar, and I think a lot of you would be very interested to know about this. This is about teacher protection, the laws on teacher protection. All right. Um, a lot of complaints reach me on about being about teachers and school administrators being subject of harassment complaints for child abuse. Madami po yan. Halos every year I receive a lot of requests for assistance on that matter. So, child abuse is the most abused ground for complaints against teachers and against schools. For every mistake, for every lapse in judgment, for any misunderstanding, the parents would always use child abuse as a ground. So, like for example, in one school, the student, the photo of the student was inadvertently missed the publication of the yearbook, and so the father complained, and the school admitted its mistake, and the school said, "Okay, we will reprint 8 copies for you, and we will now put the photo of your daughter on the yearbook." But the father would not agree unless the school reprints the more than 1,000 copies that it has already printed and released. So the school said, "Ang laki naman masyado yung cost, no?" And so they called me up and they said, "What do we do?" Because the father is so mad, so angry with the school, and is threatening to file a case. And I said, "I think you are doing the right thing. You already offered to reprint 8 copies. That is already reasonable. They don't need to have you don't need to reprint the 1,000 copies already printed and distributed to the students." And I said, "Bahala na. No? Kung mag-file ng case, then we'll just defend you." And after 2 weeks, the school president called me up and said, "O, kinakasuhan na po kami." "O, ang bilis naman. Ano po ang kaso? Ipadala nyo lang dito sa amin at sasagutin natin." At sabi ng presidente, "Ito po, finailan kami ng child abuse." Sabi ko, "Paano naging child abuse yon?" "No, there is a letter here from the lawyer." And according to the lawyer of the student and the father, the student, upon learning that her photo is not included in the yearbook, she suffered sleepless nights, serious anxiety, wounded feelings, psychological abuse under the anti-child abuse law. Sabi ko, grabe naman. No? Sabi ko, saan naka-file? Ito po, final sa barangay. Sabi ko, that is not within the jurisdiction of the barangay. No? So, it's one of those cases, no, where the schools are harassed. No? So in that case, sabi ko, harapin na lang ninyo, punta kayo sa barangay at sabihin niyo this is not within their jurisdiction. Pero sabi ng presidente, samahan mo kami, no? Dahil malakas sila sa barangay. And I said, I cannot go with you because lawyers are not allowed to join conciliation proceedings in the barangay. No? And sabi ng presidente, sumama ka na, huwag ka na lang magsuot ng costume. No? Huwag daw ako magsuot ng suit. At magpanggap na lang ako na hindi abogado at kasama nila. No? And so I said, sige, I'll go with you. So I went there. The discussion started with the barangay official saying, How much is the school willing to settle? And I said that is not allowed. No, you're not allowed to discuss monetary settlement, but only explore possible amicable settlement under the law. Sabi ng barangay official, lawyer ho kayo, bawal ho kayo dito. And I said, mas lalong bawal yung ginagawa mo. And because of that, hindi nag-prosper yung case. So that's just one of the many examples of harassment complaints for child abuse. No? So, lagi na lang child abuse ang reason. May hindi pinag-exam na bata dahil hindi nakabayad. 2 years na palang hindi nakakabayad. No, so the teacher said you go to the accounting office first and try to make an arrangement dahil 2 years na po kayong hindi nakakabayad. No, the following day, eto na, pumunta ang parent at ang sabi ng parent, my child suffered embarrassment and humiliation, psychological abuse under the anti-child abuse law. O pag hindi nyo siya pinag-exam, pa-file namin kayo ng child abuse case. O, child abuse na naman. In another case, which also involves the examination of a student, the student was caught cheating. And of course, the teacher grabbed the test booklet and asked the student to step out, and that is considered to have failed the examination. Nahuli siyang nag-cheat. No? Meron siyang kodigo. O the following day, kasama na ang parent at this time ang nagko-complain na yung parent against the school. According to the parent, when the teacher called the student's attention, who was caught cheating, the student was embarrassed and was humiliated because the teacher shouted at the student. And that because of this, the student suffered sleepless nights, wounded feelings, serious anxiety. And these are all part of psychological abuse suffered by the student. And this is a crime under the child abuse law. Yun ang sabi ng parent. No? So, lagi pong na child abuse. So, now the question is, what would be the defense of the school in case of harassment complaints against them by parents? No? All right. Now, the Supreme Court provided the test on whether the act over a child is child abuse or not. All right. In the case of Bongalon versus People of the Philippines, the Supreme Court said that not every laying of hands over a child is child abuse. Only when it tends to debase, degrade, or demean the intrinsic worth and dignity of the child as a human being that it is considered child abuse. In other words, the intention is the important element in determining or qualifying an act as child abuse. Without the intention to debase, degrade, or demean the child, there can be no child abuse. So in the school setting, even when there is physical discipline, if the intention is to discipline and not to debase or degrade the child, then it cannot be child abuse. Especially when the complaint involves psychological abuse, with more reason that the ruling of the Supreme Court in the Bongalon case finds relevance. Only when it tends to debase, degrade, or demean the intrinsic worth and dignity of the child as a human being, that it qualifies into child abuse. Without it, then it cannot be child abuse. Now, that is Bongalon case, but very recently, last year, January last year, there is another case decided by the Supreme Court, Patulot versus People of the Philippines. Here, the Supreme Court clarified that the intent to debase or degrade the child is not necessary in child abuse cases where the complaint is for physical injury or physical abuse. Because once there is physical abuse over a child, the intention is already irrelevant. In other words, you don't need to uh, to prove that there was an intent to debase, degrade, or demean. When the complaint for child abuse, the criminal complaint for child abuse is on physical abuse or physical injury. So please take note of that. So because otherwise, uh, any unsubstantiated complaint for child abuse will have to be set aside, will have to be dismissed. So you just have to know the proper defenses in case you are subjected to any case or criminal complaint for child abuse. No? Huwag niyo pong kakalimutan yung case ng Bongalon versus People of the Philippines. The intention is very important. Without the intention to debase or degrade, then it can be child abuse. And of course, if you inflict physical injury or physical abuse on the child, you cannot claim that there was no intention to abuse, no? As in the case of Patulot versus People of the Philippines, and also this case of Patog versus CSC. Here, in the case of Patog versus CSC, the Supreme Court said that in punching the student, the teacher was not exercising his right in loco parentis to discipline his student. All right. Another defense for the teacher or for the protection of the teacher is knowing that teachers are deemed persons in authority. Teachers and school administrators are deemed persons in authority by our revised penal code, such that if the teachers are or the teachers or the school administrators are assaulted, threatened, or intimidated while in the performance of their duties or on occasion thereof, a crime is committed against their person. The crime of direct assault. Please take note of that. While in the performance of their duties, professional duties, or on occasion thereof, they are deemed persons in authority, and so therefore a crime is committed against their person. No? So, in one case, a couple of years back, a university in Davao, a parent who is a lawyer and a government official went to the school and complained about the grades of his son and threatened the professor by telling the professor, don't you know that we come from a family of lawyers and killers? And with his bodyguards, he showed and displayed a firearm tucked in his waist. So this is a clear case of direct assault because the teacher of the professor was seriously intimidated while he was in the performance of his professional duties, because at the time it was I think it was the consultation, a parent-teacher consultation, when the teacher was intimidated. This is a clear case of direct assault. Please take note of that. If you are intimidated, you are seriously threatened, or you are assaulted while in the performance of your duties, there is a crime committed against your person, the crime of direct assault. E paano naman kung halimbawa ay naka-attend ng lecture natin yung may balak ng masama sa'yo? Sabi niya, direct assault kapag in the performance of your duties, di aabangan kita. Pagka sa weekend, walang trabaho at hindi ka na, while you are not in the performance of your duties, aabangan kita sa grocery at doon kita, there I will assault you and inflict bodily harm on you. So ganun ang ginawa, inabangan ka sa grocery at nung nakita ka, sinagasaan ka ng cart. No? Being a teacher, can you file a case of direct assault? Because a person assaulted you? Ang defense nung Ang defense naman nung accused, sabihin niya, na, you were not in the performance of your professional duties. This cannot be direct assault. But please take note, under the law,
it also includes on occasion thereof. In other words, even if the teacher is not in the actual performance of his professional duties at the time of the assault, if the reason is by being a teacher and being a school administrator, then it's still the crime of direct assault under the revised penal code. There is a case decided by the Supreme Court on this, the case of Gelig versus People of the Philippines. This involves two teachers in the public school, and one of the teacher is also a parent in the same school. And according to this parent, the teacher, the co-teacher, has called her son a sissy, and so she confronted her during the parent and teacher consultation or conference. And during the PTC, the uh, the parent verbally abused her co-teacher, and the teacher tried to leave and tried to go to the principal's office, but she was followed by the parent, and then she was pushed against the wall divider in the school, which caused her to fall down. And since the teacher was then pregnant at the time, it caused her to have a forced abortion. And here the Supreme Court said that this is a clear case of direct assault, because clearly the teacher was in the performance of her duties when she was assaulted by her co-teacher, who happens to be a parent in the same school. Now, this is the last topic that I'll discuss for this webinar, and I'm sure a lot of you can relate to this. This relates to a problematic parent, a parent who complains a lot, who fights with the co-parents, runs on Facebook, goes to the school unannounced, barges into the office of the principal or the president. No, a typical problematic parent. But the question is, can the school refuse to admit students on account of strained relations with the parent? All right, but before I answer that, I'd like to again refer to this academic freedom of students. Remember that students have the right to enroll until graduation, and they cannot be refused admission for as long as they satisfy the academic requirement and they follow the school rules and regulations. And in fact, the Supreme Court said in the case of Ateneo versus Capulong, only in two instances when the school can refuse admission and deny the academic freedom of students to complete the course. One is when there is academic delinquency, and number two, when the student fails to obey the school rules and regulations and has committed a serious violation. Only on those two instances. Otherwise, the right to complete the course and to enroll until graduation shall be afforded the student. Now, what about the going back to the question, can the school refuse admission of a student on account of strained relations with the parent? And the Supreme Court answered this in the affirmative. In the case of Yap Chinfa versus Court of Appeals, the Supreme Court said that if the relationship between the student and the parents on one hand and the teachers and school administrators on the other hand has so deteriorated to the level where the school can no longer perform its function, then the school administration can ask the parents to ask or to look for another school elsewhere where they can enroll their child. The Supreme Court said that this is akin to the strained relations between the employer and the employee, where reinstatement is no longer possible. So the same uh, is applied in a strained relation between the teacher and the parents. So please remember the case of Yap Chinfa versus Court of Appeals. This case reminds us that when push comes to shove, the school is not without recourse in protecting its interest. Now, as I end this webinar, I'd like to uh, I'd like to tell everyone who participated here that ours is a profession that is with dignity, and that we should live with the professionalism and the conduct required or expected of our profession, whether we are in school or elsewhere, because professionalism is expected of us at all times. So with that, maraming salamat po for attending this webinar. It has been a very long day, and I'm tired, but I'm very happy to see that a lot of teachers and educators attended this webinar. So I'll just take a short break, but after this, we can proceed with the question and answer portion of this lecture. But again, before I take a break, I'd like to promote my book, The Education Act, published by Rex Bookstore. This is available online at the rexestore.com. I-type lang po ninyo yung rexestore.com and check under the category of law books and search for The Education Act by Attorney Joseph Noel Estrada. If you're interested with the discussions on legal matters on education, then you can get a copy of this book. And I also have a few copies left here at home, so you can also get it directly from me. Just send me a message, but I only have a few copies. Siguro yung within NCR lang and within the nearby cities and municipalities outside of Metro Manila. Pwede siguro I can send through Lalamove or Grab. Or just send me a private message. If you're interested, then I can sign a copy of your book with a short message. So, again, maraming salamat po sa inyo, and I'll come back with our question and answer portion. Maraming salamat po ulit at magandang umaga sa inyo lahat. Okay.
Hello. Ayan.
Hey, I'm back. Ang bilis ah. So, joining us in this question and answer is Attorney Therese Rayan O. Aquino of Estrada and Aquino Law. Napagod ako eh. Pati pangalan mo, Attorney, nalimutan ko na.
Oo nga.
So, I hope our teachers are taking notes of our discussion. Medyo napagod ako to kasi, Attorney yan, pagod ako kahapon. Parang maghapon ako nasa Zoom sa ng Congress and Senate. Sabi ko nga parang hindi ko kaya mag-live today. So anyway, I hope I was able to explain a lot of important principles for our educators. It's very hard to compress the discussion in just 2 hours. So anyway, we listed some of the questions, so we'll try to answer them. So I hope our teachers are taking notes. Yung mga iba dito, not necessarily they don't directly answer your questions, but the more important thing is you remember the principles and also the cases. No? It's better that you remember the cases so you can research and read them again. Yung mga binanggit natin kanina, yung Angeles versus Season. I hope nag-take note sila dyan, no? Yung about student discipline, yung Vivares versus St. Teresa's College, mga issue natin sa waivers. Attorney Ann, ano ba yung mga tanong natin dyan?
Okay, sige. First, ano man tayo sa student discipline. So, is the Vivares case applicable to teachers daw? Is it applicable?
Well, ang facts kasi doon ang involve mga students, no? But if we're talking about, if the question is about yung freedom of speech and expression of the individual versus the right of the schools to regulate or supervise the conduct of teachers, the same principle applies. Pero syempre may mga ibang laws and policies also that should be considered. Pero in general, ganun yan eh. Yung freedom of speech and expression, it applies to all, not only to students, it also applies to teachers. At ang sinasabi dun sa Vivares, na in relation dun sa Tinker, na sinabi natin, di ba, yung mga cases, sabi natin lahat tayo merong freedom of speech and expression. Pero once na we injure the rights of others, kung ikaw ay nasa school teacher, yung expression mo goes against the policy of the school, of course you cannot invoke yung freedom of speech and expression. Pero syempre ang important din ngayon yung Data Privacy Act, no?
Ako siguro yung i-add ko diyan. Yes, of course, the ability of the school to discipline its teachers will also extend sa online sa mga social media natin. And since meron tayong Data Privacy Act, we just have to be transparent to our teachers na even for their conduct online, they could be disciplined. So pwedeng kunyari nag-post sila ng post na obscene. So pwede silang ma-discipline and the school can just get that screen grab yung photo na yon and they could be subject to discipline. Meron tayong isang client school na actual case na yung teacher nag-post na parang nagkaroon ng salary, hindi ata nag-increase ng salary, something like that. Tapos nag-post sila na maligning the officials of the school. So syempre, of course, we advise na definitely pwede sila i-sanction doon.
And isa pa, lalo na kung licensed teachers, mga teachers, because aside from the policy of the school on discipline and conduct, you also have to comply with the requirements of your code of professional ethics.
Yes.
Follow everywhere, hindi lang sa loob ng school, everywhere, including cyberspace and social media. You have to be professional at all times, di ba?
Especially when dealing with the students, kasi alam ko since nga ito yung new normal, marami sa atin na gumagamit mga messenger to communicate with our students. So I think the school should have a policy kasi dyan sa mga messenger, dyan minsan nagkakaroon ng issue on discipline, baka sabihin nila may sinasabing masama sa anak nila or something like that. So kailangan siguro yung school they should put in place some policy that would somehow regulate yung conduct. May nakita ko nag-comment sa kanila daw, ginagawa nila, 2 accounts daw. Yung isa, personal account, as in personal lang niya, and then yung isa yung pang school niya or yung account niya ginagamit to interact with the students.
Attorney Ann, I think may isa pa kasing area of discussion in the Vivares case, which is very important. Kasi dun sa Vivares, nag-post yung mga bata sa personal Facebook account nila.
Yes,
ng school at yun ang ginamit to discipline them. So siguro applying to teachers, paano naman yun? Diba, yung mga teachers natin nag-post on their personal Facebook account, tapos yung mga post nila is, halimbawa, libelous, damaging sa schools, or obviously using vulgar words, mga bad influence, pwede ba sila i-call ng attention ng school for those posts kahit naka-only yan?
Sorry, kahit na
naka-friends only ang view?
Yeah, definitely they can be disciplined for that post. Especially kung hindi naman, I mean, they post it in a public kahit na limited lang yung audience. Hindi naman siya something na in private na ginawa. So I guess the intention of really posting that, it's meant to, I mean, to convey a message or talagang meant for public talaga siya. So with the Data Privacy Act nga, the Data Privacy Act will not prohibit the school from disciplining those conduct naman. So the best way for the school to address this is for them to have a notice or policy that will tell the teachers that even their conduct in social media, they can be subjected to discipline.
Yeah. So sana nanonood yung mga nakikinig ng mabuti at nanonood yung ating mga teachers and school personnel. So I think ang bago natin iwan yung topic ng Vivares, ang isang importanteng takeaway diyan sa case na yan, sabi ng Supreme Court, there is no reasonable expectation of privacy over Facebook posts unless you have shown that you have employed means to restrict its view to only one person. You cannot claim privacy. So tandaan niyo po yan, ha? Pag nag-post ka ng something sa Facebook, pag hindi yan naka-only me o hindi isang tao lang ang nakakakita niyan, kahit friends, naka-friend you yan, hindi mo na pwedeng bawiin yan kung ang pinost mo ay nakasakit ng ibang tao at nakasira ng ibang tao. You cannot claim privacy pag ikaw ay inireklamo. Kaya please be reminded of that. Pakipasan na rin sa mga parents at sa mga students. It's not an excuse. You cannot use social media to injure the rights of others. Sige.
Okay, next question natin. When a student is shouted upon, would it be called child abuse or considered child abuse?
Shouted upon.
Paano daw kung 20 years old yung yung estudyante? Ako dalawang point dito. So yung first, yung paninigaw, hindi siya automatically child abuse. So again, we have to remember that the teacher has this inherent right to discipline the students. So ngayon, nasigawan or napagalitan, hindi ibig sabihin child abuse na. So it will depend on the circumstances. Di ba, Attorney Estrada?
Yes. Kasi ang child abuse, di ba, as defined in the law, it is maltreatment. It is a maltreatment of a child. May in-enumerate yung child abuse law kung anong covered acts doon. Meron isang part doon na dyan magpo-fall yung shouting. Yung mga deeds, acts, that debases, degrades, or demeans the child. So yung shouting na yan, actually kahit hindi shout yan, kung ang sinabi ng teacher is degrading, debasing, diba? To the dignity of the child as a human being, child abuse yan. Kahit pabulong pa sabihin yan. Diba? So in other words, it is not how loud the message was. It is actually the intention. So conversely,
the context also siguro.
The context. And so conversely, if the intention is not to debase, degrade, or demean the child as a human being, then it is not child abuse. Probably nagalit lang si ma'am, which is normal, no? In any act of discipline. Kahit magulang sumisigaw di ba?
Tapos, ang question niya kasi, paano daw kung 20-year-old na daw yung student? So, definitely, if we're talking about child abuse, hindi siya mag-fall sa child abuse kasi child abuse law pertains to minors. So, that's 18 and below.
Unless yung 20-year-old na yan, ang kanyang mental siguro capacity or capability is that of the minor, no? By reason of some health condition or disability. Otherwise, we presume na hindi na siya child, 20 years old na yan
So how do we reconcile this with the child protection policy na you've discussed earlier na very specific sa DepEd order na even if the person or the student is over 18, covered pa rin sila ng child protection policy?
It may not fall under the violation of child protection policy of DepEd, but if you do something to a student regardless of age, and there is ill treatment or unreasonable acts, no, or harassment or discrimination, I'm sure it will fall under a prohibited act under the school policy. Pero not entirely under. You cannot complain or you cannot complain, no, against the school on the basis of the child protection policy kasi hindi naman child yung involved. Pero like I said, kung meron kang ginawang masama regardless of age dun sa tao, I'm sure meron kang kalalagyan based on the school policies. Nasa teacher manual yan. Oo.
So ito, can we use the screenshot of student in their group chat as evidence?
Group chat? Saan ba? Sa group chat.
Group chat.
Paano nagkaroon ng kopya yung school?
So, ako siguro magandang point dito, kung hindi naman yung school ang like hinak yung computer to get the screenshot, kung meron lang isa sa party doon na nag-complain, na-screenshot, I think the school can use that as evidence kasi hindi naman siya illegally obtained. Para ka lang nagsumbong, di ba? So, as proof, ginamit mo yung screenshot. And of course, kung meron mang i-discipline doon, it's not because of the the screenshot, but because of the context. So, kunyari, kung may sinabi ba siyang masama, like, libelous ba yung sinabi niya kay teacher or nagsinungaling ba siya or something like that. So, yun yung siguro yung basis of disciplining that student. Not necessarily because sinabi niya dun sa sa chat message nila.
Oo. Tama yun. And in general, you cannot use your privacy rights to shield whatever wrongdoing you have committed. No? So, yan madalas kasi pag may nagsumbong, ini-screenshot yung chat, pinarating sa school, sigurado yung subject ng sumbong or ng report will raise a violation of privacy, which is not the case. O lalo na, tama yun sinabi ni attorney, hindi naman yung school lang nag-hack or nag-divulge ng information. No? So ang sa akin lang, pagka nasa group chat ka, mag-ingat ka din, no? Because anything you might say there, lalo na if it is an evidence of any wrongdoing, you can be sure, no, na it will be used against you. You cannot claim privacy kasi marami kang kausap sa chat. Kung dalawa lang kayong nag-uusap, yan, you can claim privacy rights. Kung lumabas yon, no, na dalawa lang naman kayo nag-usap, because clearly it is a private communication. Group chats are not private communications, kasi marami kayo eh.
Ayan, okay, sige. So next question natin regarding corporal punishment. Pag pinag-jumping jacks daw ba ang bata, considered corporal punishment ba yon?
Well, yung jumping jacks per se, hindi naman yan hindi naman yan embarrassing, hindi naman yan hard labor, 'di ba? Hindi naman siya magko-fall doon sa in excess, no, of what should be made as a punishment. Lalo na kung titingnan mo ano bang nagawa ng bata. No? Baka, di ba, baka may ginawang serious siya pero pinag-jumping jacks. I don't think that will be considered corporal punishment. So hindi naman, I don't exercise pa nga yan eh. No? I think we have as we have discussed earlier, meron kasi tayong yung authority to discipline students. Medyo flexible ang batas diyan eh. No? Basta wag lang child abuse, wag lang degrading, debasing sa bata. It can be any other form of, kahit physical, wag lang too much. And ang sabi natin, it should be reformative, restorative. It should be something naman that will serve as a deterrent for the child not to do it again. Because if it is too light, probably the child will not remember and would probably do it again. Siguro naman kung napag-jumping jack siya at pinagpawisan siya, next time hindi na niya ulitin.
Ayun. So, pwede daw bang community service? Like maglinis ng gym, pagwalisin ng gym or surrounding ng school as punishment daw?
Siguro kung pinaglinis mo yung buong gym, siguro yun sobra na. Pero yung cleaning the premises, sweeping, that's not corporal punishment. Community service yan. Kahit nga mga teachers and school administrators, they do that. If it will serve the community, it will serve a purpose, and at the same time, will serve as a lesson to the student, I don't think it will fall under corporal punishment.
Okay. Ano ba ito? So, how do we implement student discipline given the new normal?
Ikaw na, attorney.
Ako, syempre, of course, we have to create policies. Yung mga policies natin in place would be applicable even with this kind of situation. Pero, of course, meron tayo mga sa online learning natin, we have to be specific or clear ano yung mga do's and don'ts sa when we attend online class or something like that. So, again, policies pa rin. And, of course, we need to partner with the parents to ensure na the students are really complying with the rules and conduct of the school. So, ayun. So, I guess, ngayon, mahirap talaga to monitor. So, we need to seek the help of the parents talaga. So, baka ngayon, ma-realize nila, problematic pala ang behavior ng anak ko. Ngayong nasa bahay sila palagi.
Oo. At saka, ngayon, isa lang binabantayan nila. Naiimbierna na yung magulang. Imagine mo naman yung teacher na ang hawak niya is at least 25, no? Na estudyante. Siguro, it would help also for our teachers, our educators to have some scenario building, no? Habang naghihintay tayo na malift yung lockdown. Alam niyo, dati, under the normal circumstances, yung mga bata magsusumbong sa magulang, na kung anong ginawa sa kanila ng teacher. Ngayon, baka kabaliktaran, magsusumbong yung bata sa teacher na ginawa ng nanay niya habang they're doing the lesson, because now you can expect lesser intervention of teachers and school officials, and more participation of the parents in the learning process kasi nasa bahay sila. So yeah, you can do some scenario building so that you can also prepare how to address them. So, including policies on discipline. Yung policies on discipline, hindi magbabago yan. Ang magbabago lang dyan, yung monitoring and implementation. Kung may idadagdag kayo, karamihan dyan may kinalaman sa online behavior, diba, use of social media and these similar platforms. Okay.
Ito, question na set. Question po, attorney, can we classify cryptic posts as a form of bullying? Considered po there is a prior incident happened between two parties before the posting took place to social media.
Alam nyo, ang sagot dyan, kasi cryptic ibig sabihin, hindi naman, maaring hindi siya binanggit siguro, diba, kung hindi ka familiar dun sa history or circumstances, you will not identify who is the person subject of the post. Ngayon, whether the school should act on that or not, dapat meron kayong policy, meron kayong social media policy. Para maliwanag kung ano mga kasama doon. Kasi otherwise, kung wala yon, ang standard mo kasi yung cyber libel, cyber harassment, cyber bullying, which may not be easily manifest or obvious. Diba? Pero kung meron kang specific na social media policy sa school, you can define in specific terms ano yung mga pinagbabawal. Halimbawa, yung mga attacking words, insulting words directed to any member of the school, the academy, yung mga ganyan. So at least you limit the application of your school policy on discipline social media, and ma-identify mo agad kung merong violation. Otherwise, mahirap. Itatanggi yun nung nag-post Sabihin niya, it's not directed to that student.
Ayan. Sige, okay. Next question natin. Male teachers abusing male students. Ano daw cases na pwede i-file?
Ikaw na.
Ayan. So, syempre, of course, number one, kung minor yung mga students, it could be child abuse. Kung it could also fall as sexual harassment or yung violation ng Bawal Bastos Act. Yun. So, yun yung mga cases na pwedeng i-file against the teachers. Also, admin case, pwede din kung licensed teacher sila. So, you could also file a case administratively sa PRC.
Yeah. I think ang important dun sa question na yon, palagay ko, importante yung sinabi na male, di ba? Male student, a male teacher to a male student. I think ang underlying question dun is male to male. No? Yun ang tono ng question. Yes, sexual harassment applies, whether the victim and the harasser are of the same gender or sex, hindi naman yan specific sa babae lang. Ganon din yung bawal bastos law, ganon din ang child abuse law. Hindi sila gender sensitive, no? It applies to all. Ang magde-determine doon is whether the prohibited act has taken place.
Okay. Sige, eto pa. If a teacher, I guess not married to, got pregnant. So, is it a violation ba? Hindi daw siya married.
Okay. Nako, ito alam nyo, sensitive.
Controversial yan.
Very sensitive. Hanggang sa Supreme Court nakarating na to. Pero ito ang isang tandaan ninyo. Ano ito? Depende sa school. Kahit sa mga schools, iba-iba ang pagtingin nila. Di ba? Merong mga schools na very conservative about that. Meron namang hindi. No? Pero iba-iba yung pagtingin natin. Pero you have to take note. Hindi ko ito nabanggit kanina no? Yung case ni Leus versus Saint Scholastica's College, West Grove. Bakit important yun? Because the Supreme Court said that pregnancy out of wedlock cannot be the ground for dismissal of employment. Because pregnancy is not immoral in the eyes of the public. It may be unusual but not immoral. Pero, tandaan po ninyo, merong loophole sa case na yon. No? Kasi ang loophole doon, hindi na-communicate ng school ng mabuti na it considers pregnancy out of wedlock as an immoral act. So ngayon, siguro, you have to be clear. If you consider that as immoral, then it has to be communicated with the school. And there are certain levels kasi bago ka pa dumating sa dismissal, di ba? Or termination, marami ka pang factors na titingnan. Halimbawa, if the teacher is a victim of abuse, and that resulted to pregnancy, I don't think you should, di ba? You should terminate. Kaya ang isang key takeaway dun sa case na yan ni Leus is the totality of circumstances principle. No? Do not focus on the pregnancy, but on the totality of circumstances surrounding it. Then you judge whether it is immoral or not. Yung sa pregnancy na yan, that's very hard to answer directly without looking at all of the circumstances.
I think I just want to add, kasi if you read that, the decision of the court, very clear doon na with, ano school nga ulit to? Saint Scholastica?
Yes, bro.
Ayan. So, kasi, I think they base yung, they discipline the teacher based on the grounds as stated in the Manual of Regulation. So, they're saying na this Manual of Regulation was created by DepEd. So, the way you interpreted it dapat secular. So, meaning, hindi mo siya pwede interpret in a religious context kasi nga, it's DepEd. So, it's the state. So, I guess if we apply that in our specific schools, lalo na yung mga Catholic and Christian schools, they must have this specific provision na saying na dapat ang immoral ang pregnancy out of wedlock is immoral. So para pwede sila mag-rely dun sa ground na yun, sa dismissals. And I guess it's good opportunity din. I guess yung SAYAP kasi they have this yung Philippine Catholic standards, tama ba? Sorry, yan. Ayan, PCSS. Sorry, ayan. So, ito magandang i-adopt ng mga schools yan kasi it will establish na they have these certain principles and policies that will tell them na ito yung religious definition namin na this is the principles that the school will comply.
Yeah, tama yun. Very important. So, yung mga CAT schools na sa atin nakikinig, yung mga Catholic schools, please remember that if your policy in the school, whether for discipline or for employment, is founded on religious belief, on Catholic beliefs, that is beyond review by the courts because otherwise it will violate religious freedom. Diba? So, yung PCSS, maliwanag na pumasok yan sa manuals ninyo. It is cascaded all the way to your school policies. It is very strong.
And syempre, to add that, dapat pina-practice din ng school yun.
Consistently. Dapat consistently.
Yeah. Okay, so next question, can we force a student or parents to sign waiver?
Force. Alam mo, pagka may yung salitang force, basta meron yan, hindi na kaagad pwede. Kasi, hindi, ganito yan. uh, hindi mo pwedeng i-force yung parents na sumali sa isang school activity off campus. Hindi pwede, di ba? Pero kung yung magulang nag-consent na, ibig sabihin papayagan niyang isama yung anak niya doon sa school activity, pero refuses to sign the waiver, the school can interpret it as a no, di ba? Ibig sabihin ayaw nilang sumama, hindi pwedeng hilaw. No? So in that case, pwede mo silang i-compel because it is part of the school policy that once you agreed or consented to participation in a school campus activity as a matter of school policy, you have to read and understand and sign the waiver. Because if you do not sign it, it means you do not want to send your child to the activity. Ngayon, kung ayaw niyang pumunta, wag mo pilitin, no? Or ayaw niyang pumirma, wag mo na lang pasamahin. Dapat meron yung school na alternative activity in campus, no? Or an alternative activity that they can join. Otherwise, magagalit sa iyo yung DepEd.
Ako siguro add ko lang, when we say force kasi, hindi, yung force as a factor to invalidate a contract, hindi siya yung mere hesitation eh. So, may mga instances na talaga napipilitan yung parents, pero eventually nag-consent din sila or nag-sign din sila sa waiver. So, it doesn't mean na force talaga sila.
Tama. Alam ko yung sinasabi mo, Attorney Ann, yung pumipirma naman, tapos later on, afterthought, sasabihin, pinilit kami.
Pinilit lang sila.
Kung yun ang gagamitin nila at nagreklamo sila sa korte at kung saan man sa DepEd, it will not fly. No? Kasi force means duress, you are compelled, you had no other choice. No? There is that influence that you cannot resist. With your own volition, no? Undecided ka lang, you cannot find fault.
Okay, ito. May time pa ba tayo? Magtatanghalian na sila. Pero very important tong question na to. May student na ni-rape daw ni stepfather. In denial si mother. So what should the school do about it?
Ang nagsumbong ay estudyante against the parents.
Si stepfather. Tapos, I think, yung bata, nag-seek din ng help sa mother, pero si mother in denial. Ayaw maniwala. So, anong gagawin ng school?
Unang-una, dapat i-process ng school yan. Siyempre, they have to validate whether there is merit in the complaint. Yung muna sa bata, wag mo nang sabihin sa magulang, otherwise, di ba? Baka walang mangyari doon. So, you just validate first in whatever means that you have. Go to the guidance office. Dapat merong in an atmosphere that is not in an investigative environment. No? Kailangan free magkwento. And then once you have validated that, even as against the parents, as against the natural mother and the stepfather, the school should act on it. Child protection policy, I think within 48 hours ang nakalagay sa DO 40. Dapat isumbong yun agad, ipaalam sa DepEd, otherwise may penalty yan. And also under the child abuse law. If you have the knowledge and information that the child has been abused, you have to inform, otherwise you also have a liability. Pero for your protection, yung mga school authorities natin, you are also protected by law. No, you are immune from any administrative or civil complaints for reporting the child abuse complaint. So it's both a duty and and a right, no, on the part of the authorities to handle child abuse cases against parents.
Right. In addition, so you can report yung case sa DSWD, sa police, or other law enforcement agency, or sa barangay ninyo.
May tanong, Attorney Ann, kailangan daw ba notarized ng waiver? Kasi may rin eh. Kung kami po ang abogado ng school, dapat may notarized kasi babayaran kaming notary.
Ako, naman ang notary kasi, it's for, in some cases, for convenience siya kasi you don't have to prove yung execution niya. Kasi in-acknowledge or something like that. Pero for the validity, I don't think it's necessary for the validity. Pero syempre, yun nga, mas magandang notarize siya.
Kasi kahit sa batas, hindi lahat ng documents are required, no? In fact, enumerate lang ng batas kung anong dapat notarized. Kaya lang tayo nagno-notarize to make sure na yung pumirma isang tao lang, no? Yung pumirma at saka yung nakapangalan dun sa document. Kaya ako sinasabi yon, if there is any other way for the school to make sure or ensure that fact, then you need not have it notarized. Kung kaya naman, for example, ng ating mga staff sa student affairs, 'di ba, office, na pagka submit ng waiver mo, pinirmahan doon or nakita naman natin, hindi na kailangan i-notarize kasi minsan cost pa yan eh. Diba? So if we have the means to prove and validate whether the signature and the name of the person there are one and the same, then you don't need notarization. Kasi minsan nakala ng iba pag na-notarize okay na. Meron ako isang alam na school yung pinagnonotaryuhan nila, no, for more than 9 years. Patay na pala. Kasi sabihin sa waiver, pa-notarize yun dun sa baba. Hindi nila alam yung nagtatatak doon yung assistant ng abogado na 9 years ago patay na. Lalong problema 'yon, no. So hindi po required.
Okay. So meron pa ba tayong time? Meron tong isang question dito. Okay pa?
Sige.
Yan. Attorney, paano naman po yung teacher ang binuli ng mga students in social media? What can a school do to discipline the student? Maraming ganyan, no?
Maraming ganyan. Una, technically that's not bullying. No? Kasi yung ating anti-bullying law applies only bullying of students, no? Student to student. So yung bullying of a teacher, technically hindi siya magpo-fall sa anti-bullying act. Pero bullying in a sense, baka in general sense,
aggression, parang gano'n.
Aggression, 'di ba? Ill treatment, maltreatment, or physical assault, 'di ba? So hindi, syempre it's a misconduct, no? Whether it is on social media or in person, syempre hindi mo pwedeng gawin 'yan sa any person in the school. Lalo na school authority, 'di ba? A teacher is deemed person in authority. So the teacher should be given respect due him or her. So tingnan niyo, mamili kayo sa pwede niyang na-violate sa student manual. I'm sure marami doon, no? It's a misconduct, obviously. It's a misconduct. Pero kung meron kang specific na social media policy, ayun ang gagamitin mo, no, against the student para mabigyan siya ng sanction. O meron pa ba?
Actually, marami pa yung ibang haba.
Sige, last siguro. Last 2 questions. Ikaw na pumili.
Sige.
Dami.
Dami. Hindi, yung related sa parents. Kasi very interesting yan. Anong stand ng school pag may dalawang bata ang di nagkaintindihan at nakisawsaw ang parents to the point na sinugod ng parent yung bahay ng bata? Kailan or paano makikialam ang school sa away na involved na ang parent?
Unang-una, dapat hindi tayo nakikialam sa sa away ng parents, no? Pero siguro
hindi, kasi dito merong yung parents sinugod yung bata.
Sinugod sa bahay. Syempre, di ba, ang sabi natin yung the duty of the school to secure and protect the child, no? From any harm, to maintain a safe and secure learning. Lang yan, within what is reasonable. Mahirap naman siguro kung pati bahay ng mga bata ay mababantayan natin yung mga yan, no, against harm. So I think yung authority ng yung school doon, no, to yung liability nila to protect them even in their homes, hindi na. Wala na tayong liability. But of course, maraming pwedeng gawin yung school for that to be prevented, in a positive way, not in the form of providing rules and sanctions, but in a positive way, no? Create a positive environment where including the parents, all members of the academic community, where they respect each other. It can also provide a venue where parents can air their grievances and the school can mediate. Pero wag namang do not encourage them. No? Otherwise, wala na tayong ibang gagawin kundi pagbatiin yung mga magulang na nag-aaway. No? Mauubos ang oras ng school. Only within what is reasonable under the circumstances. Last.
To what extent po ba pwede makialam yung nasa taas, I guess supervisor to, or kinauukulan tungkol sa mga posts or pinopost ng mga teachers or students sa social media in terms also sa personal na buhay ng iba?
Okay. Di ba, sabi natin, freedom of speech and expression. Kasi ang general rule is, the general rule is, you can express whatever you want. Because there is freedom of speech and expression. This is not trivial, ha? Yung freedom of speech and expression, it is part of the Bill of Rights. Nasa Constitution yan. And even in the enumeration of fundamental rights in the Constitution, freedom of speech and expression ranks highly, no? In all of the other privacy rights, in all other liberty and property rights of the person. Andun siya sa taas. It should be respected. No? But it is not absolute. Sabi natin may limitation. Pero so ang ibig sabihin nun, ang burden is on the one who is trying to stop you from expressing yourself. Ano yung mga yon? In general, if it injures the rights of others, you cannot injure the rights. You cannot commit a crime. Okay? You cannot commit a crime. Kung libel yan, cyber libel, di ba? Hindi mo pwedeng sabihin freedom of speech and expression yan. Di ba? O sedition. Sabi mo, kung sinong makakapagbigay sa akin ng 100 million, bibigyan ko ng 50 million. wala naman. Wala rin naman. May sabihin, kung sinong papatayin yung aming principal, bibigyan ko ng 2 million. Is that a crime? Is that libelous? Is that, yun ang tanong. No? Otherwise, kung hindi yun mapoprove, then meron kang freedom of speech and expression. Ngayon, sabi nga natin, kung gusto mo, malimit yan within the teacher's function and relationship with the school community, dapat magkaroon ka ng social media policy. Kasi doon sa tanong, di ba, personal post. Kasi ngayon, hindi mo alam kung kailan ba nagiging personal yung teacher or part of function of being a teacher. Kasi nag-i-interact pa rin naman siya with the same people. So, it's very hard to determine. So, para once and for all, ma-regulate mo yung conduct nila being teachers, dapat meron kang social media policy. Otherwise, again, we go back to the general rule that freedom of speech and expression. Teachers and students do not shed their constitutional rights to freedom of speech and expression when they enter the schoolhouse. Thinker versus
Add ko lang din dyan, I think yung mga posts that will arise to a misconduct, ito yung mga posts that will affect the morale of the students, of the teachers, or it adversely affect yung school rules and regulations. So kung it's something na kahit na, kasi marami nagtatanong paano kung may pinost daw yung, kunyari, for example, yung school is pro-administration and then yung students or teachers against administration ng government. So, nagka-clash yung mga ideas. So, ako lagi ko sinasabi na kahit na hindi nagsusubscribe yung teacher sa post yung idea or advocacy ng school, it doesn't mean na violation siya kaagad. So, you have to balance din kasi nga, they enjoy this freedom of expression. So, kung pro-administration, tapos yung school against administration, hindi nyo naman pwede agad-agad na i-discipline. Unless nga, the post itself is obscene, ganyan, or it violates some school rules or regulation.
Teka, ito, i-ano natin ng konti. Last na. Ang dami nagtatanong, paano ito? Lalo na ngayon, no? Yung parent, nag-post sa Facebook, sabi niya, mga walang hiya itong school na ito. Ang laki-laki pa rin ng tuition, ang daming miscellaneous fees. Ano na nga tayo, new normal na. Hindi na nga mag-report yung mga bata sa school. Ang laki-laki ng i-charge yung tuition, no? Kayo, mga abusado, magnanakaw, o anong pwede gawin na ito? Ayan ba, freedom of speech and expression pa rin. Sabi niyan, mga abusado yung mga nasa school na yan, hindi kami magbabayad dahil sobrang laki naman, nagnanakaw na kayo. O ganun. Paano, ano bang view dyan dapat? Well, una, syempre, freedom of speech and expression, pero pag yan ay libelous na, ang subject is the school. Sinabi, magnanakaw, di ba? There is a wrongful imputation. No? of a crime or a wrongdoing, and it is malicious, kahit hindi yan directed to a particular person in the school. If it is directed to the school itself, remember the school has a separate personality distinct of its officers. Ang ibig pong sabihin yan, kung yung school itself, as its reputation has been besmirched, it can also file a case for cyber libel to protect its reputation also. So, warningan nyo yung mga parents na gano'n. Baka naman bugso lang ng damdamin dahil nung binigay ninyo yung kanilang diba? So, kausapin na lang yun. Let them know that there's a proper way to air their grievances and not posting this on. O, sige.
Okay.
Kailan tayo mag consultation? Dapat 2 hours question and answer lang. Okay ba sa kanila? Okay ba sa inyo 'yon? Thumbs up dun sa kasi kung hindi, wag na lang. Pero kung I think we have to do that, no? One of these days, baka next week. Mag Q&A tayo, Q&A lang sa mga gustong magtanong in relation to schools. Tapos siguro sa ibang araw na lang yung mga non-school related kasi marami rin nagtatanong sa atin, Attorney Ann, na na mga cases, mga walang access sa lawyers. Minsan kasi hindi naman kailangan ng actual representation, minsan kailangan nila ng information sa batas.
Yes.
So, mag-schedule na lang din tayo ng gano'n yung mga non-school issues, non-school legal issues. Okay? O siguro, we just have to end here. O wag niyong kalimutan yung libro ko, ha? May nagtatanong, meron po bang certificate? Meron ito, libro. Meron akong few copies dito. So kung gusto niyo may pirma.
Sign copy.
Sign. Konting-konti na lang So, para mapirma natin. Pero kung hindi naman, pwede sila mag-order online sa Rex e-store. So okay, thank you. Thank you
very much.
Salamat sa Rex Bookstore, Rex Academy, and of course sa Raxo City. Thank you sa magandang screen namin tsaka sa layout. Maraming salamat. Thank you again. Mag-ingat po kayo lahat. Keep safe everyone. Bye-bye. Bye-bye.